Our second case this afternoon is case number 25-0465, Thomas Home Corporation versus Emerald Coast Utilities Authority. Appellant's counsel, you may proceed when you're ready.
Good afternoon. Todd Leduc on behalf of Thomas Home Corporation. If I could reserve 4 minutes, that'd be great.
Noted. Thanks.
We are here today on an 8-year-old case that should go to the jury. We've not had that opportunity yet. We had a trial in 2025, 7 years after we filed the complaint in this case. The court entered a directed verdict on all counts after our presentation of the evidence. It gets somewhat complicated in here with sovereign immunity and these other things in here. We've been up to this DCA before. I don't think any of y'all were on the panel, but there was a brief about that. There was a denial underneath of ECUA's motion to be deemed sovereign and then to have the caps that come from the statute applied. This court said that was untimely. It was a put cart before the horse kind of stuff like that when we did it. So we came back down and we went forward with that. The court eventually enters another summary judgment based on the same things, and I can go over that evidence in a minute, but we go to trial. We put on our evidence. The court enters a directed verdict, which when it happened, and you have trial counsel here, we're both trial counsel, we were trial counsel down below. I literally turned to my client and said, she just ruled on the motion to dismiss 7 years later. Is literally what I said to my client, because what she says in her directed verdict was already argued, briefed, and ruled upon at the outset of this case. She ruled that ECUA, the name gives...
You stay behind the mic.
I'm sorry.
This for future lawyers that want to hear these arguments.
I'm sorry, I'm a trial lawyer mover. I'm sorry. I will try to stay glued to the podium. It's Emerald Coast Utilities Authority, right? Not Escambia County, Emerald Coast Utilities Authority, right? Emerald Coast is a region, right? Not a single county, right? I mean, that becomes important in some of the analysis over here. But the name itself kind of gives that up, about stuff like that. So she ruled that a governmental entity, now let's just presume that ECUA is a governmental entity, right? When you go to a sovereign immunity type of analysis, is there, for a negligence, we had a negligence count, negligent misrepresentation for an email that we got. We followed the procedure. You got to have your engineer say whether you can hook up a sewer system. I know more about sewers than I ever dreamed I would know now, 7 years into this. But my client owned a piece of property that he could gravity feed using the earth and gravity into an existing subdivision where he owned a lot. He could go underneath that subdivision into the street in front of that lot and go to a lift station, 307. A lift station is just a big tube in the ground with 2 pumps in it that keeps it pressurized because it goes to a force main, which is on a main road, which takes the bad stuff all the way to the poop plant, all right, all the way out there. But you got to do it under pressure. And those lift stations cost money to build, right? And if you can get a piece of property where I can gravity feed into an existing lift station, that makes that development far more opportunistic for a small builder who runs a family operation like my client. He sees that, he does it. But before
Okay, counsel, I have a question for you.
Yes, sir.
You spent 7 years learning about the sewage treatment. I spent about a month learning about it. Can you please identify in the record where Emerald Coast granted lift station capacity? Not sewage, not water, but lift station capacity for more than 50 lots at lift station 307. Where in the record is that?
It is in the reservation and in the letter where you put in for, they actually approved us for 172 lots.
So I didn't read that.
For lift station 307. And then if you go to the concurrency letter, which goes to the county, because you can't get a permit unless you got some kind of plan for what you're doing. You can't use buckets, right? You can't have an outhouse. You got to go to the county to do that. So you need that concurrency letter, which is good for a year. That concurrency letter talks about that exactly. Now, Emerald Coast has taken the position that, oh no, that doesn't mean the lift station. That just means the plant 5 miles away has capacity. Well, that makes no sense. You've got to get it there. I literally asked the director in his deposition, am I supposed to take it in buckets? What? I got to get it there somehow. You're just approving that it's available somehow and not how I get it there? It makes no sense whatsoever about what that is. But it is actually, and if you look at it, it's signed by multiple people. It's a different engineer than even Mr. Hamill, who kind of went through this stuff, Hamlin, it is in the reservation letters. 307 is specifically identified multiple times. It's the only lift station that works. Moreover, there's other record evidence where it literally talks about the gravity feed issue with that. The only time that ECUA ever came back and said, you can't hook up, because we eventually asked for 152 lots, right? We go from 50 plus or minus is what the email says, because he's looking to buy the property. I don't know how many lots I got. I don't have an engineer. I just need to know that the earth and ECUA will let me take the bad stuff from the houses I want to build on this property down to lift station 307. How can I get it there? I don't have to go across anybody else's property because I own a lot in Pine Brook Estates. And I go under that lot that I own and put it into a manhole cover that's in front of my street right there. And it takes it all the way over there. So it is integral to this analysis about what it is. There's no other lift station talked about. Moreover, ECUA was already planning on replacing that lift station. It bought a piece of property right next to it, real property next to that lift station that is sitting there today ready for a new lift station. The only thing that happened here is they said, uh-oh, we got to get somebody to pay for this. Thomas Home Corporation. And that's exactly what happened here. It was down to the last minute. We get an email in January that says, oh, hey, surprise, I know that we do it. We're working with them the whole time. 152 lot process, we're working with the engineers. Our engineer, David Fitzpatrick, is working with the engineers at ECUA every day. Talking about this, we got to go under wetlands, do the rise, figure this out, this kind of pipe. All that stuff's happening. Email. Sorry, no, can't hook up. I need a $600,000 golden lift station and you got to pay your fair share of that and here's what it's going to cost. Literally, just out of the blue, an email that says that. The only analysis that is in the record, and I think it's the only analysis that's ever been done, the only analysis that says that that lift station does not have capacity, does not, includes other properties that have never connected. The only analysis, if you look at the analysis that Hamlin did, in this case, it's in January of 2017, he says if you hook up all of this stuff, Thomas Home Corporation and this other 45 lot thing, we can't do it. Okay, we may agree with that, but that has nothing to do with whether Thomas Home Corporation had the reservation, had the right to do it, and was misled into buying property that is now, and until just recently when we've been able to do something, not what he intended to buy it for. And we relied on that. Back to what the judge said in the directed verdict. She ruled that ECUA had no duty to provide accurate information from its engineers to hook up to a lift station. No duty at all. You never get to sovereign immunity under her analysis because there's no duty on ECUA to do that. The engineer can lie with impunity. Can you hook up? Sure. How many? I don't know, 500. Okay, build your project. Oh, sorry. Can't hook up at all.
What's our standard of review on that?
De novo.
Okay.
Absolutely. So that's a key point with that because that's one, okay? Now, she's wearing a belt and suspenders on this case too, so there's other things that follow with that, but that's number one. I don't even get to sovereign immunity. There is no duty as a matter of law that an engineer with information that only they have. We don't have any information about what ECUA is doing, what people are hooked up, how much flow rate is going through that stuff. That's why that email is important. We have no idea what that is. The process was you ask the engineer, hey engineer, can we hook up some lots? Yes. Then you get your plans going, can we hook up this many lots? Sure you can. Here is and it's a guarantee, Your Honor. Guarantee is what that letter says. We guarantee you 172 lots. Guaranteed. Not maybe, they guaranteed it. Then they come back and say, no, you got to buy a new lift station. But she says there's no duty, so there can be no negligence. Secondly,
And that's the general black letter rule for government entities, right? I mean, that's not a foreign rule.
No.
There's plenty of cases
If
that say that.
in fact there is no duty, like for example, it's pretty clear there is no duty to maintain accurate records that you can sue on and stuff like that. You know, like the cases that are cited, they were all cited before too, by the way. Where somebody's got something on the wall and the map's wrong and you look at it and you're like, oh, you published this map, the map's wrong, I should get that. There's no duty there. And all the cases about no duty, separate and apart from sovereign immunity, for no duty, talk about this public records kind of request stuff. One of them is about, they're asking him about the floodplain under the federal rules. Do I have to, am I complying with the federal FEMA laws? They're like, okay, they don't have any duty to give you legal advice. All that stuff makes sense. However, there is not one case, and believe me, I've looked, there's not one case that stands for the proposition that an engineer with parochial information obtainable only by him, not known to the general public, can lie to you with impunity from a governmental entity, a private governmental entity, but from a governmental entity, assuming that they are. There's no case that says that. And it makes perfect sense because you have no other way to get there. You have no way to do
I'm trying
it.
to figure out what's the issue here, whether the engineer can lie to you or whether he has a duty to provide accurate information. Because I don't see anything that says he lied. So which
Well, they admit that he misrepresented the flow rates in there. The ECUA admits that.
he gave you incorrect information.
Potato, I say misrepresent, you say gave you inaccurate.
Well, I mean, giving someone inaccurate information is, lying seems like you have a burden to show that he affirmatively told you something that was incorrect on purpose to hurt you.
But I'll grant you that, Your Honor, sure. But he misrepresented this stuff, and I can tell you why he misrepresented it. They admit that he misrepresented the flow rate. So that email says 220 gallons per minute. That's how much the pump is putting out, right? If you've got bad stuff going in at 300 gallons per minute, you're in a bad situation if you can only pump out 220, right? Because now it's overflowing. If you got 2 gallons a minute going in, you got plenty, right, to do that kind of stuff. So he uses a 220 gallon flow rate in his email and says, you're good to go. It says 200 more houses. Maybe it's 200 houses total, maybe it's 200 more, that's really not the point. He says, your project is good to go. This lift station can handle it. That is the misrepresentation, not simply that. It's because I believe he misconstrues what the flow rate was.
Are you talking about the Fitzpatrick email?
No, I'm talking about the Corey Snyder email to Mr. Fitzpatrick.
To Mr. Fitzpatrick, yeah.
Yes, sir.
Was
That's
that
right.
only about whether or not they can handle 50 houses?
50
not
plus?
Not about flow? Gallons per minute?
It is. He puts that in there. He puts 220 gallons per minute in the email itself. That is how he gets to the analysis that they can handle more houses. Here's the dirty little secret with that. They didn't know what pumps were in there. During discovery, we had to go out with a crane, empty the thing, and pull pumps out of the hole and get the serial numbers off of them to figure out what they were. ECUA didn't even know. They didn't even know what the pumps were in that one. That's why it's a misrepresentation. He didn't even know what pumps were in there. The key to that is it's more than just you can build a gravity feed and this lift station can handle it. 50, 20, I don't care what that is. He says it can handle it, right? We never get any.
Isn't there a lot of hedging in this email? I mean, they seem to average, I also estimated. It appears that this will be fine as long as your client owns the property. I mean, it's all this hedged-oriented language that you're presenting as something more solid than it seems in this hedge language can support.
Well, what that does, Your Honor, and that's the way they did it. They don't do it this way anymore. They don't do it this way anymore. They do not do it this way. But it was an email between engineers about this stuff. It's way more formal now, way more formal about what it is and you put it in these forms and stuff like that. But back then, that's what that was. And that is the go-ahead to buy. We send them a PDF of the property we're going to buy, which abuts that lot that we own that's on the street with the things. He buys that property as a result of that. And we go forward.
An email that says this appears to be fine?
Yeah, and then on top of that, then we do a reservation for 172 gun. Then that's a guarantee for a year, and then we're back to 152, which is the number of lots. You had some wetlands, and you had to put some stuff in there for holding ponds and things like that, so you don't get all of that out of there. So 152 is what we had going forward. So we were even under that, and there is no analysis from ECUA that demonstrates that there wasn't capacity. There's just not. The record evidence is not out there, and they never allowed us anything. We actually did a formal review petition in front of the board to try to get an answer. They would not give us a written answer. We tried to appeal it on the transcript. This court dismissed it back and said, no, we've got to have a written order. They didn't file a written order. They wouldn't give us a written order to tell us one way or the other how many we could have. We've been fighting this thing for 8 years with a monopoly that picks and chooses what rules it wants to follow. It's not part of the APA, but it's a governmental entity, but it's sovereign, but it's I don't have to comply with this. It is a pick and choose of what you want to do in a monopoly where you have no other choice but to go there and do that and rely on those types of statements along the way.
All
And
right,
it
you're
is-
deep into your rebuttal time. You can continue, you may continue.
Thank you very much.
You may save your time.
If I could reserve I'm at 21 seconds, maybe a minute.
All right, yeah, why don't
Thank you,
we
Joe.
give a minute each side?
Thank you.
May it please the court, Philip Pugh with Litvak, Beasley, Wilson, and Ball here on behalf of the Emerald Coast Utilities Authority. Judge Neff put his finger on it in the very first question that I heard asked from the bench, which is there is a fundamental failure of logic in this lawsuit. The Emerald Coast Utilities Authority was asked on a very informal basis, do you see any problem if we try to put in a 50-lot subdivision? The engineer took a look at it, as Judge Osterhaus acknowledged. It was a look. It was an early look. It was a lot of estimation in there. But he said, yes, 50, it should be fine. That was the conclusion. It should be fine. There was never a time in the history of this litigation that ECUA was not okay with them hooking up a 50-lot subdivision. In fact, they're building a 50-lot subdivision right now. The issue is they came asking for 152. And when my client said, well, let's say she can't handle that, you're going to have to cost participate so we can upsize it, they sued us. Now, the representation at best was 50 lots are okay. Now I'm defending a lawsuit because we said 152 is not okay. It doesn't get any simpler than that. The concurrency letter is a different creature. And it does say it's either 52 or 72 lots on the concurrency letter. The part that they leave out is that all of this communication, both the email, the Snyder email, and the concurrency letter, these all take place between the engineers, okay? So just to start, for example, with the Snyder email, this is an email between an engineer at the ECUA and a private engineer that was hired, without our knowledge, but hired by Thomas Home Corporation. These gentlemen speak the same language, okay? Mr. Fitzpatrick testified at trial that he knew that email was not binding. He testified at trial that he did not think that it meant they could have 200 additional homes. He thought it meant they could hook up 50. He testified at trial that he knew the concurrency letter that said 172, I believe, does not relate to lift stations. He knows that because it's in the ECUA manual, which he works with all the time because he's done 20-something residential subdivisions. This is all on the record. The only way you can create confusion here is if you try to take it out of context and treat it as if this engineer was sending it to a layperson who had no idea what he was talking about. But between these engineers, the record could not be more clear. They both knew what they were talking about. This case, it fails on multiple grounds. First and foremost, there's no legal duty. Now, I don't think there was a misrepresentation, and I'm going to talk about that even more. But we can't even get there with a legal duty. There was some discussion about how it's somewhat confusing and convoluted with sovereign immunity, but it's not. The directed verdict order actually said sovereign immunity is not implicated here. I don't get there because there's no legal duty. As I recall, what Judge Rakoff actually said was, at a previous hearing, I determined that this entity is the type of entity that has sovereign immunity, but I don't have to go there because as a governmental entity, they don't have a legal duty. Now, that is not new information, and Mr. Lucer is correct when he says that the judge has seen this before. There's nothing new about it. We've argued this on motion to dismiss. We argued it again on summary judgment. I repackaged it and argued it again on directed verdict. But there's nothing new or novel about it. The cases are, and could not be more clear, and they're lockstep. I've cited the court to maybe a half a dozen or so cases. I think the most important ones to look at are the Freedbird case. That's the 2nd District in 87, Hillsborough, 2nd District in 99, Dunedin, 2nd District in 2018, Alderman in this court in 23. In fact, Judge Roberts and Judge Osterhaus were signed on to that opinion. Every one of them say the same thing, that a governmental entity has no legal duty to convey accurate information. The developer in this case tries to distinguish this a little bit, saying, well, this is personal information. This is information that's personal to this person, but it doesn't hold any water. First of all, the case.
Did you take your brother's argument earlier? He started off with saying this isn't a county we're dealing with. This is just the Emerald Coast. It seemed to be his argument was you're not a governmental entity, or there's something about your status that doesn't give you the benefit of these cases.
Well, the status argument, I believe, goes to whether or not we have sovereign immunity. We did get an early ruling on that. It didn't end up mattering in the end. I think if the question is, are we a governmental entity, then I would simply ask the court to take a look at what we put in the record with our motion for summary judgment. Your Honor, let me tell you the facts that we identified by affidavit. All of these, and let me back up. One of the things they keep saying is that the ECUA likes to declare itself to be an agency for this and not an agency for that. The ECUA is a creature of statute. What they're talking about is the enabler. The Florida legislature is the declarer in the legislation. And the legislature said in the Enabling Act, the ECUA is an agency for purposes of the public record law. They're an agency for purposes of the Sunshine Law. They're not an agency under the definition set forth in the APA. Anyone aggrieved by the agency will have the same remedies as somebody that was aggrieved by the county or the city, which means going to the circuit court, not directly to this court in an administrative way. And so that's sort of who they are. Now, when I proved that up for my summary judgment, I put affidavits in the record that proved up the following things. The ECUA is subject to Chapter 218, which governs financial matters pertaining to political subdivisions. Okay? All of ECUA's property is public property, held by ECUA for the benefit of the public. ECUA does not pay property taxes. ECUA does not pay sales taxes. ECUA board members are elected from the 5 electoral districts within Escambia County, Florida. And every one of them has to file an annual statement of financial affairs. Everyone has to complete ethics training. The ECUA is required to adopt an annual budget and file it with the state for approval. The ECUA is ordered by the Enabling Act to conduct disciplinary proceedings at least as protective as those set out for the Department of Management Services. They are required to contract for a management audit. They're required to keep public records open. They're required to publish their annual reports. They have to publish notice when they set rates. They engage administrative law judges through the Division of Administrative Hearings for purposes of HR issues. They're allowed to issue tax-exempt revenue bonds. They exercise eminent domain.
So the upshot of all this is that you've cited a bunch of cases involving cities, county, and a town, and you're in that boat.
Absolutely, and it's a governmental entity, and all the case law that I read says, they use the term governmental entity, regularly. And back to the
special district. Is that what you mean?
Sir, yes, sir. So it's interesting. There's a whole thing in the brief about whether we can be a special district and an independent special district. It's somewhat nonsensical. There's what's called a special district, and then you're either an independent one or a dependent one. This entity is an independent special district, meaning it doesn't work under the county. In fact, the reason the name was changed to Emerald Coast was not because it was across the panhandle. They're authorized to operate in the Escambia County and immediately adjacent properties, but only if they have capacity. They're elected by the voters of Escambia County. They changed it to Emerald Coast instead of Escambia County Utility Authority because they kept getting confused with the county. They would get complaints that would go to the county and vice versa, and so that's the reason that they actually did that. All that being said, these cases that I've cited the court to, the half dozen or so that I just recited, they do involve personal information that's specific to a particular requestor. Just for example, in the city of Dunedin, the allegation was that city employees reviewed development plans, approved them, and then came back and said, wait, they don't comply with our development code, you're going to have to change something. That's as personal as it gets. And the court said, there's nothing you can do about this here because there's no duty on the part of the entity to give accurate information. Hillsborough is a good example. The developer in that case was told that a water main was in a certain location based on a map. He built his subdivision. Water main wasn't there. So he sued the city to make them build it for him. And of course, they had no legal duty to tell you where that water main was accurately. They can be wrong about it. So I don't think we ever even get to the question of whether there was a misrepresentation. However, if we even got there, then, as I think I kind of started with this, is that the parties to that email knew exactly what it meant, and they testified as much. It's in the record. The next thing I want to touch on is the intent is interesting. For a misrepresentation count, you have to show an intent to induce this plaintiff to do something. We raised the issue that ECUA had no idea who the plaintiff was, who the developer was. The email comes in from the local engineer who we do business with all the time. He says, hey guys, can you take a look at this with this work? They said, yeah, it looks like it'll be okay. That's the whole story. ECUA didn't know Thomas Holmes was involved for several years. Now, they argue that that's some kind of a standing issue. They're trying to say that, well, undisclosed principals can have standing. But that wasn't our argument. Our argument is that I can't intend to induce Thomas Home Corporation to buy a piece of property when I don't even know Thomas Home Corporation is in the mix. They didn't even know they were communicating with anybody from Thomas Home. It didn't matter to them at that point who it was.
It didn't matter that you knew some developer was in
Some
the mix.
developer.
You just didn't know which one.
That's right. We didn't know about this plaintiff. I think that it fails on intent there. There's no justifiable reliance because, again, the engineer Fitzpatrick testified he did not think that it meant 200 new homes. That's on the trial transcript of 407 through 410. Mr. Henry himself testified that he didn't consider the issue of how many houses he could build to be all that important. That's why he didn't clarify anything. That's in the trial transcript at 107. They never asked for more than 50 lots, and Mr. Henry himself testified that ECUA on multiple occasions invited him to submit a set of plans for 50 lots, and they would approve it, or 152, but he would have to contribute to upgrading the lift station. He simply refused and then sued ECUA, asking the court to enter an injunction, ordering ECUA to allow him to hook up 152 lots to a lift station that ECUA's engineers say can't handle it. The failure of logic here to me is just, it's fundamental. You cannot rely on a representation about one project to be binding on another project that's 3 times as big. The reliance theory fails for that reason. I believe it breaks any causation as a matter of law. There is some discussion in the initial brief, it wasn't argued in the argument earlier, regarding a duty to serve, that my client breached a duty to serve. That we acknowledge that there is such a thing, there's a duty to serve. There's a few cases on it. It was actually interesting, it was new to me. I had to read up on it when I first saw it in here. What it says is that the public utility has a duty to serve to the extent of its capacity, okay? There's this whole tug of war that is going on currently with growth and development. The general rule in the utility industry right now is growth pays for growth. If we have capacity, build as many houses as you want, hook up. If you drive the demand above what the capacity is of the existing infrastructure, then you have to pay for the upgrades. The developer has to pay for that.
And that sounds like there's a fact issue because from what I heard from your brother, he said that, yeah, there's these other subdivisions out there, but they didn't hook into this thing. So that there's this unused capacity there is sort of what I gathered here.
There's a whole thing about the pump capacity. So in that initial email, the Snyder email, one of the questions that was raised was, were his calculations about the pump capacity right? That whole thing about them having to go out there and pull the pump out with a crane and look at it was utter nonsense. There was some confusion at one point in this 8-year of litigation and a piece of discovery where I think my client had said that's a 220, and then we came back later and said, no, we got that wrong, it's a 100. Here's the thing. The lift station is designed for a 220-gallon pump. And this is all, by the way, I'm not just pontificating, this is in the record. Mr. Piscopo, the director that handles lift stations, testified to this. It's designed for a 220-gallon per minute pump. You can't expect it to go above that. If you put in a bigger pump, then you're outsizing the wet well. The wet well is what gives you the safety factor, so that if the pump shuts down, it'll hold for a while until they get out there with a pump truck instead of backing up in people's houses. Now, the interesting thing is, when you build a, say in this case, a 220 gallon per minute station, people start hooking up. You're not going to have that much flow, right? That's its maximum capacity. And what they find is that sometimes they can drop to a smaller pump until such time as the load requires the bigger pump. It saves some power. More importantly, it gives better head pressure. That's a physics thing I don't understand, but somehow with a smaller pump, you get higher head pressure in the line and things work better. And so what he testified to was, it was 220s. I told him to go take them out and put the 100-gallon pumps in there. The 220s are sitting on the shelf, and at any point in time, we can pump them right back in. That's why all the analysis that you saw from the engineers were based on the 220 gallon per minute design specs, because that's as big as it gets. The whole concept of what size pump is in that wet well, it is a complete red herring based on that testimony. And again, that's in the record. Mr. Piscopo explains that in the record, and I'll give you the exact site. It's in the trial transcript at 206 through 212. Back to the duty to serve for a second. The testimony was clear that ECUA offered multiple times to let him hook up to 50 lots, or to let him hook up more if he wanted to cost contribute. And that's the reason we got directed verdict on that. That was the evidence that was before the court. They simply refused to take advantage of it. The solutions that were offered never changed. ECUA was always okay with 50 lots. They were always okay with more than that if they wanted to cost participate. But there was never a time when they couldn't get the 50 they asked for. If there are no other questions, that'll conclude my arguments. Thank you.
Thank you, Mr. Beard. Rebuttal?
Okay. Quick and dirty. The record evidence about the things that he just said that Emerald Coast Utility Authorities did from the affidavits, not all there. Record 2207 to 2208 is the judge's order striking portions of these affidavits that he introduced in the second go-round for the summary judgment for sovereign immunity. There were affidavits put in that said, I think we're sovereign. We do all these things because we're sovereign. It just total legal conclusions. I moved to strike all of them. The judge literally just took out portions of sentences in these affidavits, which I could find no case law that says that you can do that. She was literally rewriting affidavits for people who submitted an affidavit that said, we're sovereign because the Enabling Act gives us this. It was just all either legal conclusions or stuff beyond their personal knowledge. And it's stricken. Even with the little bit that she struck, that is an inaccurate reflection of what's in the record. So number one.
Your time's finished. You may briefly conclude.
Thank you, Judge. APA. The definition in the APA changes after the Enabling Act. Definition in the APA changes after the Enabling Act that makes them an agency. The Enabling Act change was not substantive, it was procedural, so it applies to them along the way. In 1980, I think it's 81 or 83 is when the Enabling Act comes out. APA changes that along the way, and that changes what the definition is. They're now included. It's a water district that's in that thing. Words like that.
Thank you.
Yep.
All right, that concludes our session this afternoon. We're adjourned.